that I signed, there's already a contention there because they call it the home loan agreement, but there is no contract actually entitled on the cover page called the home loan agreement. There is no such contract. There is an email and a letter, a piece of whatever that I signed with them called the letter of grant, and a letter of grant that they keep referring to as the home loan agreement. So I'm contesting that for the sake of accuracy, and if we have to be really accurate in these courts and in this law, then there is no contract called the home loan agreement, and they keep referring to the home loan agreement. Okay, and I'm using that as this little sticky issue. The other important thing is that in the mortgage bond agreement, they suddenly sneak in this word called lawful money. I have to repay the loan, the home loan, with lawful money. That's never been mentioned before. Now, in my definition, my research, lawful money means government bonds and gold and silver. Now, suddenly they want me to repay this with gold and silver and government bonds. That's not ever been disclosed to me. So, on the one hand, I'm trying to show the court that there's definitely malicious intent and underhanded activity and fraudulent activity on behalf of the bank. And if I can show that, I'm not sure what the law is. I need to find out. If the contract is found to be fraudulent, is it enforceable? I don't know. I need to find that out.
Well,
excuse me.
Here's the deal on all that. These are the same kinds of issues that anyone in the world is going to run up against. Here in the United States, for instance, the Federal Reserve notes, as they were originally issued under the Federal Reserve Act, they stated right on the note, we'll pay to the bearer on demand $5, $10, whatever, $100, whatever. We'll pay to the bearer on demand. That is, they were to be redeemable in lawful money, which had been declared to be defined. A dollar was defined as so many, so much a volume of gold or silver. They also said on the note, right on the note itself, this note is legal tender, which could be interpreted to mean lawful money. This note is legal tender for all debts public and private, and is redeemable in lawful money at the United States Treasury or at any Federal Reserve Bank. So, in effect, the very pledge on the notes themselves indicated that they were not lawful money, but that they were representations of lawful money. Now, if we get off into that area, the leverage that the banking system will apply against you is that somewhere, and you may have discovered this already, or you may be about to discover this, somewhere in the purported laws, and I mean to stress the word purported, they'll be claimed to be laws, and this is what we really need to challenge. But in the purported laws, somewhere the bank has been provided the purported authority to do whatever it is doing. And so the bank's defense is to claim that they're in compliance with purported law. However, if you have this provision that any contract has to provide lawful consideration, and even we have a further case which we can argue in your behalf. However, our arguments are not really even dependent upon that. It's just a plus in our favor if lawful consideration is a law in contracts, because that means that while the bank might claim whatever it does, whatever laws support their activities as they are, nonetheless, they're in violation of lawful consideration, and those laws which have provided them to do so, therefore, have to be null and of no effect. So your real argument, and I sound like I'm getting technical as I'm listening to myself here, because what your situation really emanates from is an obfuscation of the currency. And the banking system is the obfuscator. They're actually committing a criminal act against all of us, not just you. And this is why it's important for everyone to understand your case. But it's also important for everyone to understand this obfuscation of the currency. Now, basically, what happens in nature with the promissory obligation is when it's fulfilled, that is, when the principal is paid, it's retired from circulation. The only value that a promissory obligation derives is derived from the fact that it's an actual promise to give up something of equivalent value to whatever it represents. Because we denominate our promissory obligations in the currency of the land, that means that if I purchase a $100,000 home, for instance, by issuing a promissory obligation, that the real creditor who gives up property, the house, for the promissory obligation can use that lawful currency, and it is an inherently lawful currency. In fact, it's really the only inherently lawful currency. So I was a bit surprised to hear your list of lawful money as cited in the laws of South Africa. What they mean to me is that the authors of the law hadn't resolved the issues. And of course, this is the case in every country of the world. Because the banking systems are protected as obfuscators, as criminals, actual criminals against us. So
well, that's exactly what I'm trying to break through here, and I think we've got a very good shot at it. And I'd like to cut this discussion reasonably short because I'm starting to get drowsy from the medication or the stuff that I took, and I'm going to be starting to slur very soon. And but what I'd like to say to you, Mike, is that basically my argument, what I stated earlier about some of the inconsistencies in the contract, is something I need to deal with some really sharp lawyers here and find if there's a precedent here to say, if we can show that the contract they made me sign or was actually signed on my behalf by somebody because of a power of attorney, which I've also shown
the lawyers can't help you. The lawyers can't help you because what you really need is the help of a theoretician, that is a developer of, which is my expertise. That is, it's my work that 43 years ago uncovers this obfuscation of the currency, which invalidates laundering the principal into the possession of the banking system and imposing interest on it. There is no lawful way in any country of the world for the principal or the interest to ever become the possession of the banking system. Now, it's my work which is the reason, really, that there is so much reaction in monetary reform circles now, where people have accepted, albeit largely as a consequence not of understanding the issue, but just somehow believing that interest is unjustified. And we have a Freedom of Information Act appeal against the Bank of England right now, asking what written records, and we actually asked for any records, but we've been forced to ask for what written records exist, that the bank ever gives up lawful consideration in the creation of money. And they have been unable to provide this an answer to us. Of course, they do not give up lawful consideration, and so what I'll hope to explain to you in our further discussion then is that there is no actual debt to the banking system because it never gives up lawful consideration. All it does is publish further evidence or representations of your promissory obligation, which by extension exists only as an obligation to pay and to retire principal from circulation. And so what I want to warn you against is that you don't really want to claim that you're paying off the debt of your promissory obligation by issuing a like irredeemable promise to pay to the banking system. You are intending to resolve that purported falsified debt, and on either grounds you have a right and are fully right in doing so because they never gave up lawful consideration. So, if private citizens have equal rights, you have a right to do so. And if they have a right to do so without giving up lawful consideration, then you have a right to do so. And so you have done so. And you can make that promissory obligation infinity because you're making no provision, like they're making no provision ever, to redeem it in property of the bank. So there's no lawful consideration, and you prevail on that ground. Now, your lawyers can't help you to do this, although they might research existing law. Your case really is one of human rights, regardless of whatever laws may be purported to exist. So, like I say, if lawful consideration is a fact in South African law, this is a situation which increases our leverage, but which is not indispensable to our arguments because, in truth, there's no rational way to understand that there is an actual debt to the bank. So what I'm cautioning you against is not to argue that you're paying your actual promissory obligation, but you are resolving the falsified debt to the bank. You're not doing this to skate from your actual debt. And so under a resolution of what your promissory obligation actually amounts to, you would be 12 times in general under today's economies further ahead on your payments. You might have already resolved this debt. So I would like to explain all those things to you further here in the next time that we have an opportunity to visit.
That'll be great. If I can just conclude this by telling you what, and the people that might be listening to this, what my take on this is my main objective here is to get this case to trial. I want to get to trial because at the moment we're still in the hearing stages in the Supreme Court. We're not in a trial situation where we can call witnesses and put them on the stand and cross-examine them. I believe at that point it's going to be that's what we need to do because the bank cannot afford to do that because the moment we put the CEO on the stand, I can get some really smart people like you and others to come in there and cross-examine them and they can incriminate themselves.
Right.
My objective is to get it to trial, but to get there, I need to provide enough evidence that I have worked through this, and I'm claiming the Bills of Exchange Act. Now, in South Africa, the Bill of Rights, the Bill of Rights, according to our Constitution, is the supreme law. All laws fall under the Bill of Rights. In the Bill of Rights, I'm entitled to a fair trial. Now, I'm using that to get me to a fair trial, and I will basically appeal any decision until I get to the Constitutional Court and get given a fair trial so we can cross-examine the bankers. That's where I'm going with this. And what I'm using as an argument is to say that if the law applies to everybody, the Bills of Exchange Act should apply to everybody, and we should all have equal rights and ability to use the Bills of Exchange Act. I paid this amount off to the bank with a bill of exchange. In in the South African Reserve Bank Act, which is one of only 4 reserve banks in the world